This is Paul Turner, the Immigration Barrister at Imperium Chambers. Please subscribe to my channel and hit the notification button for up-to-date immigration news. A question that I'm often asked is, can I bring a domestic worker to the United Kingdom? Well, yes, there is a route. There is a specific visa outlined in the immigration rules which pertains to overseas domestic workers. This essentially permits employers that are going to be staying in the United Kingdom for a period not exceeding 6 months to bring their entourage, as it were, or of employees to the UK to help them while they are in the United Kingdom. There are some stipulations to this to stop it being abused. The domestic worker must be at least 19 years of age. This is obviously to protect children. The domestic worker must have already worked for their employer for at least a year before they can apply for the visa. This will obviously carry an evidential burden, payslips, etc., and is obviously intended to stop people just saying that they've just employed somebody to bring somebody over. They must not intend to stay in the United Kingdom for more than 6 months. This can be a bit of a pain, but that's as good as it's going to get. And they must be coming to the UK with an employer who does not intend to remain in the UK for more than 6 months. So this is very much a scheme for some wealthy individuals potentially that want to bring people to them bring someone with them to the United Kingdom. If we look at these 4 requirements in turn, age, it's fairly self-explanatory. A domestic worker must be 19 years or older. Employment history. The employer of the domestic worker must provide a letter to confirm that the domestic worker has been in employment for at least a year, along with one other piece of evidence spanning that period. Now, obviously the Home Office like to say no, so it's important that you get the evidence right. This evidence can include payslips or bank statements showing a salary, confirmation that tax has been paid on the employment, confirmation of health insurance that has been paid for the employee, and a contract of employment. I mean, that's a pretty clear one that the person has been working for a year or more. A work visa, residence permit or equivalent passport endorsement from the country in which the domestic worker has been employed by the employer, so that the person coming is obviously in the country or the old country lawfully, and a visa or equivalent passport endorsement to confirm that the applicant has travelled with their employer. So again, to show that the person is actually a genuine employee. Unfortunately, it's limited to a 6-month stay, and the relevant immigration rules require that the applicant will leave the UK at the end of the 6 months in the UK, or at the same time as their employer, whichever is the earlier, and they will not live for extended periods in the UK through frequent or successive visas, which is designed to prevent people from just going away to France and coming back for another 6 months. And they will not make the United Kingdom their main home. This again is to limit it really. Travelling with the employer. Now, this is also fairly important. It's a given that domestic workers applicants must intend to travel in the company of their employer's spouse, civil partner, or their employer's child. Now, turning to money, written contract and minimum wages. Now, modern day slavery exists, and so the rules obviously are set up to prevent it. Now, the applicant and their employer must agree a written employment contract consisting of duration of employment, in the employee's duties, i.e. what they're supposed to do while they're in the United Kingdom, the number of hours that they're supposed to work, so that we can see, or the government can see how often they're working, what holiday requirements are being given to the domestic worker, so again it confirms that the employment is genuine. Also that the employer must pay for the employee's travel to the UK, and they must pay for their visa fees, etc. The employer must also provide accommodation, but if it's for a domestic worker, that's likely not to be too difficult. And then a crucial one, which is something that was exploited before, is that the employer cannot keep the employee's passport. The contract must also establish that the employer will be paid in accordance with the National Minimum Wage Act 1998. If the Home Office is not satisfied with this and thinks that the person is being paid less, they will not be granted a visa. Now, turning to the final, which is frequent or successive visits. It used to be that people could bring domestic workers for long periods of time. Now this has been cut back to 6 months. So it is a major precondition that the domestic worker will not intend to make the UK their permanent home through extended visits or frequent visits. An intention to contravene this or break this rule could lead to the visa being refused. Domestic workers will have no recourse to public funds. They must have no intention to study in the United Kingdom and are permitted to work only as domestic workers. The visa fee in this occasion is £516, and it is not a route that leads to settlement. Now, this is a particular type of visa. I've been asked about it a few times, so I thought I'd produce a video on it. So, in short, yes, you can bring your domestic worker with you. They've got to work with you for for over a year, and they can only stay in the country for 6 months. It used to be more flexible. It's not now. I think that's just the government's way of cutting back on immigration and also preventing people from being exploited. Hence the reason why the employer cannot keep hold of the employee's passport. I hope you've enjoyed this video. If you have any concerns or questions, or you wish to apply under this route, please do not hesitate to contact me. Thank you very much for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.